Hello, everyone. So glad to see you today. For those who don't know me, I am Radiance Harris, and I'm the founder and managing attorney of Radiance IP Law, and I help emerging businesses protect, monetize, and grow profitable brands with trademarks. And today, we are going to be talking about what happens or what you can do as a business owner when someone copies or steals your brand. Okay? So this is a fairly common scenario in today's very social and digital world. Even if you have a primarily local business, you have a digital footprint. So it's easy for people to see your business name, your logo, slogans you're using by going to your website or going to your Facebook page or your Instagram. So even if you have a primarily local business, you could be vulnerable to theft, someone copying or stealing the brand that you have spent your blood, sweat, and tears building, and money too. So today we're going to be talking about what you can do as a business owner when you find out that someone has stolen or copied your brand. So there are two particular scenarios that I'm going to use today to illustrate what are your options in either of these scenarios. So with scenario A, that's essentially you've been in business for a few years now, but you never actually trademarked anything. So you don't have any pending trademark applications or trademark registrations with the U.S. Patent and Trademark Office. And then scenario B is you've been in business, you have U.S. federal trademark registrations, and then someone steals your brand. So we've got scenario A, and then we've got scenario B. Okay, so with scenario A, so this is the one where you've been in business and you haven't protected anything, you haven't secured any trademarks. So in that situation, you have what's called common law trademark rights. So if you are based and located I'm in Maryland. So I'm in Maryland, I'm located in Maryland, and let's say I've been doing business for 5 years, but I haven't gotten a trademark. So what you have what's called is common law trademark rights. Your common law trademark rights are limited to Maryland only, regardless of the fact that you may be servicing or exposing yourself to clients and customers nationwide. But without a U.S. federal trademark, you have common law trademarks or common law trademark rights in Maryland. So what that essentially means is if someone were to copy your name outside of the state of Maryland, wherever you're headquartered, you would not be able to prevent them from doing that. You would not have any recourse against them. However, if there were someone in your same state or in the state of Maryland and they were to copy your name or your logo or whatever brand asset that you've protected with a trademark, and they're in your same state and you find out that they started using it after you did, then yeah, you could prevent them from doing that solely based on common law trademark rights. But without a trademark registration, you only have common law trademark rights, and you cannot prevent anyone from all of the other 49 states from copying or stealing your brand. You have no recourse. So let's think about the other scenario B. So scenario B is you've been in business, you've gotten your trademark registrations for whether it's your business name, maybe it's product or service names, maybe it's a logo. So you've gotten those protected. And then you find out that, someone has copied your brand. Let's say you're on Instagram, you see someone copied your brand. You, my friend, would be able to not only get Instagram to take it down because you would provide your registration certificate to them. So that's automatic presumption of legal ownership when you have a U.S. federal trademark registration. No questions asked. This person's copying my business. Here's my certificate. Boom, it's down. Secondly, you can also send them a nastygram, or what I like to call a cease and desist letter. So you can send them a letter legally referencing your federal trademark rights to get them to stop using or stop copying your brand. Thirdly, you can sue them. You can literally sue them in federal court, and you would be able to get damages, attorney's fees, and more because you have a federal trademark registration. So if you have any questions as I'm going through this, feel free to drop those in the comments and I'll be sure to address those. So in the second scenario, or scenario B, with the US federal trademark, that gives you the exclusive nationwide legal ownership and protection to use your name. So you are the exclusive owner to use the name that or the logo, whatever it is that you've protected, you have the exclusive right to use it in your industry. So like in my case, I have a federal trademark registration for Radiance IP Law. I have the exclusive right to use Radiance IP Law in connection with legal services. So no one else can trademark Radiance or Radiant or anything else in the trademark as a trademark in the United States. And so that's what it gives you, is that ability to have exclusive rights in your field. And so when you don't have that, when you don't have a US federal trademark registration, you don't have that nationwide protection, you don't have that exclusivity, and you don't have that legal ownership. So it's a lot more complicated. So let's say in the example I provided, if you found out that someone on Instagram basically copied your trademark, they started a page to start selling competing products and services, and you tried to put in a complaint on Instagram or any social media platform, really, they would not be able to accommodate. They would not be able to answer to your demands because there's no actual proof of legal ownership. And you scrambling to find documents and stuff, they're not going to determine, ownership based on that. Because as I mentioned, the trademark registration is automatic proof of legal ownership. So that's the difference between the two scenarios, is that scenario A, no trademark registration, no or very limited recourse. And then scenario B is you have been in business, you have trademark registration protection, so you can not only prevent someone from stealing or registering or applying to register your trademark, but you can also then take legal action once you found out about it. So that's kind of the difference, as you see. And to play it out, a common scenario that I get, especially when prospective clients want to come and schedule with me, like for example, years ago, a clothing and apparel company, New York based, came and they said that someone told them when they started their business back in 2015 that, oh, you don't need a trademark. Don't listen to those people. Whoever tells you that, don't listen to them. But basically, someone told them they don't need a trademark. They didn't get a trademark. So come to find out, a year after they were open for business, literally a competitor took their identical name, started selling clothing and apparel. And then the junior user went and secured a US federal trademark registration for that name. So what happens now? So the clothing and apparel company, they came to me, they had these aspirations of being in stores, retail and department stores nationwide with their brand. But now, because the junior user, so even though they started using the mark after then, they started using the trademark outside of New York. So again, common law trademarks are only limited to where you are located. So they started, this third party started using the identical mark as theirs, then went and registered it as a trademark, got a trademark registration for it. So now that third party has nationwide rights, exclusive rights to use the name. And they have basically pigeonholed the prior user to New York. So their dreams and visions of being in retail stores nationwide came to a screeching halt simply because they didn't secure the trademark when they launched their business to ensure that they had the nationwide legal exclusive rights and protection. But this other third-party competitor beat them to it. And so now that competitor can be in nationwide stores and retail stores. And that's that. And so here you are, now you're 4 years into business, you build a name for yourself, you build a brand and reputation, and now you are faced with the decision of whether you should continue to use this name, knowing that your options are limited now. Your options are limited. You can't do what you thought or envisioned that you'd be able to do, or rebrand. So you can continue to use the name that you have with limited options, or you can rebrand. That's basically the scenario. And so another example I give you is with my own personal story, is that when I launched Radiance IP Law, I, of course, filed for Radiance IP Law when I launched, or shortly after I launched, or it might have been before, but in any event, I have a trademark registration for Radiance IP Law. And as I mentioned, I have the exclusive rights in Radiance in connection with legal services nationwide. Come to find out, a competitor, another attorney, tried to file for Radiant for legal services. So because I had a prior trademark registration before them, my registration blocked them from being able to be registered. And then on top of that, I was able to send them a nastygram to get them to stop using the name because they are infringing on my trademark rights. Again, that is what I'm able to do because I have a US federal trademark registration. I'm able to prevent others from doing it. And essentially, when you don't have a trademark protection, you're building your business on a brand that you don't legally own, which is kind of like building a house on land that you don't own. Like, I'm sure you wouldn't completely build like your dream home on this land that you don't own, because at that point, someone else has the power to determine the future of your business. You're not in control when you don't have ownership. Brand ownership is king, or I guess you could say brand ownership is queen. But it is the ultimate thing that you need as a business owner to ensure that you are in control. Because of course, a lot of us, we go into business because we like being in control. We like having the freedom to do as we wish. We like having options. And that's what a trademark allows you to do. It allows you to have options. So where your business may be now, your business might be somewhere else completely different. It may be a lot larger. You might be doing a lot of different things, maybe a couple years later. But because you protected your trademark now, it gives you the option to do what you need to do later. It gives you the option to enforce. It gives you the option to expand. It gives you the option to license. It gives you the option to sell if you decide to, because trademark rights are actual tangible assets, just like real estate, but they're for your business. So they're actually taken into consideration when you're getting a loan. They could be consideration when you're getting valuation over how much your business is worth. Intellectual property rights are a consideration in connection with that. So it's very important to actually own the business and the brand that you are building. So let me check to see if there's any questions or anything in the comments. Okay, I'm not seeing anything. Okay, so I'm just checking my notes real quick. Okay, so here's I guess you could say some questions you can ask yourself about whether it's a good time for you to trademark your own brand assets. And by brand assets, I mean your business name, your brand name, your product or service names, your logo, anything that serves as a source identifier in your business. Meaning when third parties see that name, that logo, anything in connection with your products or services, you want them to automatically think of you and not your competitors or all the hundreds of thousands of other people who are doing exactly what you are doing. So that's what I mean by brand assets. So here's some questions you should ask yourself to determine whether now is a good time to take action and start looking at securing trademark protection if you haven't already. So the first question I will ask you is it a name Is it a logo? What have you? So think of your brand assets. Do you love it? Like, is it something that you love? Like, what kind of emotion does it give you when you think about your business name? When you think about your logo? What kind of emotion? Are you excited about it? You love it? The second question I want to ask you is like, have you used it or are you using it long term? Or planning to use it long term, rather. So have you been using it long term, and or are you planning to use it long term in the future? So if either of those questions are yes, we go on to the third. The third question is, does it have the potential or is it already making you money? So is it the focus of your business? Is it your bread and butter, or will it be your bread and butter? Meaning this is how you pay your bills, pay yourself, pay your, everything, you pay your staff. Is this business your bread and butter? Or is it the potential to be your bread and butter, meaning it's bringing you in money? And then the last question I'll ask is, what emotion does it invoke in you if you found out that someone copied or literally stole your business name, your logo, any of those things? What kind of emotion? Are you pissed? Does it piss you off? If it pisses you off, then yes. If you've answered, if the answer is yes to those 4 questions, then my friend, it's time for you to get a trademark ASAP. If you've answered yes to all of those questions for any of your brand assets, it's time to start the trademark process, because it means it's a very valuable asset that you should very much be protecting. Okay? So just making sure I didn't miss anything in my notes here. Okay. So I'm sure you've all aware of there's a recent trademark infringement case against Clubhouse. The big Clubhouse app that everyone's going, Looney Tunes over. But in any event, they were recently sued. They were recently sued by an Arizona company who owns a U.S. federal trademark for the Clubhouse for a sports. It's like a sports, like a networking site for sports professionals, is my understanding. But in any event, Clubhouse is valued at over, I think, $4 billion. So it's valued at over $4 billion. They just launched the app like last spring. So it was during the pandemic. But what's so crazy about this whole thing is that Clubhouse has no trademarks. Like, they did not have any trademarks, no trademarks filed, nothing, which kind of leads me to think that they didn't do their due diligence or trademark search or anything like that before actually adopting the name. But in any event, this Arizona company, The Clubhouse, so it's one word, The Clubhouse, they have trademark registration for it, covering a networking site for sports professionals, and they've filed a trademark lawsuit against Clubhouse. And so this is a really good example of like what you can do as a U.S. federal trademark registration owner. When you are a brand owner, you have the ability to protect and enforce your trademark rights, even to the extent of filing a trademark lawsuit. And just so you know, like, trademark lawsuits are expensive as heck. We're talking about hundreds of thousands of dollars spent on legal fees. And then the winner, if the plaintiff wins, they could get, on average, it's about $1 million in damages for trademark infringement. So it's not a cheap thing if it does happen. So that's just something to keep in mind. So this is a good example of, again, what a U.S. trademark gives you is options. The options to protect and enforce your trademark, the option to monetize it and make more money from it. A lot of people are saying with this Clubhouse matter that, I guess because Clubhouse was valued at so high, it's an opportunity for the other party, who I guess isn't as well known as the Clubhouse app, to get a big payday, which is not uncommon. Like, they're claiming basically reverse confusion. So what reverse confusion is like basically when a little guy is basically saying that the bigger guy people are confusing the two, so much so that the bigger guy is more known and making more money. And so they're taking business away from the Clubhouse, which is a lesser known app. So it'll be interesting to see what happens in this case. In my experience, a lot of trademark cases do eventually end up getting settled, but I think it'll end up being interesting to see how that plays out. But in any event, the whole point of me sharing that is to illustrate what can happen when someone copies your brand. As a trademark owner, you do have the ability to enforce your rights. So if you're in a position right now where you have not considered trademark rights, I encourage you to reach out and let's schedule a trademark strategy call. My passion is definitely helping with the trademark strategy. You do need a strategy before you move forward with filing your application. You should never just, let's file the application. You should have a strategy, and that strategy should be based on what your goals are, what your vision, what your actual business vision is, will determine the best strategy for protecting and enforcing your brand. So I hope you found this session helpful in better understanding what your options are when someone copies or steals your brand, when you don't have any actual US trademark rights versus when you do. And as you see, it's a lot easier, a lot more powerful. You have a lot more options when you have that trademark registration. So let me see if there's any questions before I wrap it up. Doesn't look like we have any questions. All right. Well, thank you guys for joining me today. I look forward to seeing you again next week. Until then, take care, guys.